So let's talk a little bit about the no contest clauses, because every will and trust litigation case that comes in potentially has something to talk about when it comes to no contest, or maybe it doesn't. And there's a lot of confusion about when they apply and when they don't.
Yeah, no contest clauses may be the most misunderstood concept in trust and will litigation. I got a call from a gentleman the other day saying, wanting me to come into a case that he needed help with a lawyer. And I started explaining to him, undue influence and lack of capacity, and then I asked him if the trust in the will or the will had a no contest clause, and he immediately retorted back, they do, but those don't matter in California any longer. And so that just goes to show you a little knowledge in this area can be very dangerous. And currently, as it stands, no contest clauses in California, they are outlawed for the most part, but there are 3 areas where they're not outlawed. And that's something that people need to pay particular attention to. And so when you get clients coming in and telling you that no contest clauses don't apply, or you get a lawyer that doesn't do trust and estate litigation on a regular basis, believing that no contest clauses are not an issue that need to be worried about, that's a problem. Basically, there's 3 types of categories where undue influence, there's 3 areas where no contest clauses still apply in California. And the first category is a direct challenge to the trust or will's terms. The second is filing a creditor's claim, basically asking for something back in the trust or the will by way of a creditor's claim. So the third way is trying to change the nature of property.
And when you say a direct contest, you're talking about an actual petition to try and overturn a trust or a will.
That's right. So if the will says, I have 3 kids and I want to give them all 1/3 of my estate, if somebody comes in and says, I'm going to file a petition in the probate court because mom told me before she died she wanted to give me all of it, and my other 2 siblings she didn't want to give any of it to, and there's a valid no contest clause in that will or trust that says if you challenge the terms of this will and trust and lose, you're going to be disinherited. That is still alive and well in California, and so that needs to be carefully reviewed before you determine whether you want to file any type of petition in the probate court. You recently had a case that you were working on where you were kind of sensitive to the idea of no contest clauses, and maybe you want to talk about that.
My pet peeve when it comes to no contest clauses is that there's an area where they most definitely do not apply, and that's where there's a lot of confusion, and that is if you're going to challenge the actions of a trustee in terms of the way that they're managing the trust estate, or an executor in the way they're managing the probate estate. If you're challenging just the trustee's actions, so you're saying that they didn't invest properly, or they spent money they shouldn't have, or they took fees that were too high, or they didn't make distributions that were required under the trust, these are all things where the no contest clause does not apply. And there's so much confusion about that because almost on a weekly basis I'll get a call from somebody saying the trustee's not doing what they're supposed to do, but there's nothing I can do about it because there's a no contest clause, which is just not at all accurate, because there's something very much you can do about it. You can hold their feet to the fire, and the no contest clause is not going to be a factor in that type of case.
Does that keep the trustee or their attorney from alleging that you have violated or triggered the no contest clause?
Well, unfortunately, no. And I always say that you can be sued at any time for anything over any reason. And so if I were representing a beneficiary and I go into court and I say the trustee's not managing this trust estate properly, and so we're going to challenge how he's managing it, the trustee could come back and say, aha, you've triggered the no contest clause and therefore your client should be disinherited. It's a completely irrelevant, non-applicable argument in my opinion, and it'd be hard to imagine that that type of argument would ever actually win in court because there's simply no law to support it. But that doesn't mean that a trustee can't beat that drum and make a whole lot of hay out of that type of issue, I suppose.